about the Second Amendment. 3 of us protested, but to no avail. Now, let me be clear again. I'm not suggesting that the court's decision was influenced by the senator's threat, but I am concerned that the outcome might be viewed that way by the senators and others with thoughts of bullying the court. This little episode, I'm afraid, may provide a foretaste of what the Supreme Court will face in the future, and therefore I don't think it can simply be brushed aside. The senator's brief was extraordinary. I could say something about standards of professional conduct, but the brief involved something even more important. It was an affront to the Constitution and the rule of law. Let's go back to some basics. The Supreme Court was created by the Constitution, not by Congress. Under the Constitution, we exercise the judicial power of the United States. Congress has no right to interfere with that work any more than we have the right to legislate. Our obligation is to decide cases based on the law, period. And it is therefore wrong for anybody, including members of Congress, to try to influence our decisions by anything other than legal argumentation. That sort of thing has often happened in countries governed by power, not law. A Supreme Court justice from one such place recounted what happened when his court was considering a case that was very important to those in power. He looked out the window and saw a tank pull up and point its gun toward the court. The message was clear: decide the right way, or the courthouse might be, shall we say, restructured. That was a crude threat, but all threats and inducements are intolerable. Judges dedicated to the rule of law have a clear duty. They cannot compromise principle or rationalize any departure from what they are obligated to do. And I am confident that the Supreme Court will not do that in the years ahead. When we look back at the history of the American judiciary, we can see many judges who were fearless in their dedication to principle. And one who is especially dear to the Federalist Society springs immediately to mind. I'm referring to Justice Antonin Scalia. Nino was one of the law professors who helped the society get started, and during his long judicial career, his thinking influenced generations of young lawyers. He left his mark in many ways. Perhaps above all else, he is renowned for his advocacy of 2 theories of interpretation: originalism, the idea that the Constitution should be interpreted in accordance with its public meaning at the time of adoption, and textualism, which is essentially originalism applied to statutes. To see the extent of his influence, consider these 2 statements by Justice Kagan. Quote, "We're all originalists now," and, quote, "We're all textualists now." What do they mean? These statements do not mean that all jurists are in complete agreement about how the Constitution and statutes should be interpreted. But what they mean is that a lot of the debate about constitutional and statutory interpretation now takes place within the framework of, or at least using the language of, those 2 theories. And going forward, a lot of the debate among Justice Scalia's admirers will probe his understanding of these theories. I will not go deeply into that subject now, but I will say that we have seen the emergence of what I believe are erroneous elaborations of Justice Scalia's theories. And I look forward to friendly and fruitful debate about where his thinking leads. As I discussed tonight, the COVID crisis has highlighted constitutional fault lines, and I've criticized some of what the Supreme Court has done, but I don't want to leave you with a distorted picture. During my 15 years on the court, a lot of good work has been done to protect freedom of speech, religious liberty, and the structure of government created by the Constitution. All of this is important, but in the end, there is only so much that the judiciary can do to preserve our Constitution and the liberty it was adopted to protect. As Learned Hand famously wrote, "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can do much to help it." for all Americans, standing up for our Constitution and our freedom is work that lies ahead. It will not be easy work. But when we meet next year, I hope we will be able to say that progress was made. At that time, I trust, we will be back together in the flesh. Until then, I wish you all the best. Thank you.